What one federal court taught Lincoln National about ERISA disability claims for type 2 narcolepsy. Narcolepsy is a sleep disorder that causes an uncontrollable urge to fall asleep suddenly during the day, and it's almost impossible to resist this urge. There are four main symptoms of narcolepsy, which should be developed in your medical records. There's excessive daytime sleepiness, sudden muscle weakness, sleep-related hallucinations, and sleep paralysis. And there are also two main types of narcolepsy, which are classified by whether you have cataplexy or whether you don't. Now, type 1 narcolepsy involves cataplexy, where you'll experience a sudden muscle weakness similar to how your body blocks movement during REM sleep. Cataplexy can be triggered by positive emotions like laughing, making jokes, or other forms of humor-related behavior, as well as surprise, fear, and anger. And that can occasionally trigger these episodes. Type 2 narcolepsy is characterized by excessive daytime sleepiness without the muscle weakness and is triggered by emotions. And it is treatable, but there's no cure for narcolepsy. It's a lifelong condition that can prevent you from working and can entitle you to your ERISA disability insurance benefits. Now, when you are applying for disability benefits, it is really crucial that your medical records are documenting your story. And I'm going to tell you the story of Nurse Bombassi's experience with Lincoln Life and what one judge did. Now, the Social Security Administration acknowledges that narcolepsy can be a disabling medical condition, but many ERISA disability carriers, like Lincoln National, just don't get that. They take a completely different approach to analyzing a narcolepsy claim and deciding whether or not you meet the applicable definition of disability that prevents you from performing your own or any occupation. And the analysis, as I've said here, begins with that definition of disability because you have to provide medical documentation and proof of your diagnosis and that you meet the applicable standard of disability. And in this case, Ms. Bombassi's policy required her to be unable to perform each of the main duties of her occupation, which their training, education, or experience would reasonably allow. Now, Ms. Bombassi had worked for more than 20 years as a nurse and as a nurse practitioner. She stopped working originally because of a shoulder injury. She had rheumatoid arthritis, and she had extreme daytime sleepiness that was diagnosed as narcolepsy. After she was paid her own occupation benefits for her inability to be a nurse, Lincoln said, "Too bad, so sad, we're done. We think you can perform other work." And they ignored a favorable Social Security decision that found that she had less than a sedentary capacity to work because she had to obviously lay down for a couple hours during the day as a result of her narcolepsy, and she could be, functioning 1 minute and not functioning the next moment. That wasn't enough for Lincoln. They cherry-picked her medical records, questioning the diagnosis despite the objective testing and the lack of alleged restrictions and limitations associated with her narcolepsy. And in response to that denial, she submitted medical records that documented from her physicians her diagnosis and her functionality issues. And she even sent in sworn statements from her family and friends who had observed these episodes of narcolepsy. And these sworn statements were rejected in part because Lincoln took the position she had worked for many years with narcolepsy and nothing had changed, when in fact she couldn't continue to work. What they ignored was that her previous employer allowed her to take naps. Now, the real issue here is whether any employer in the national economy is going to allow an employee to nap 2 hours per day, and whether the skills that she had would be transferable to any other kind of occupation. Ultimately, the judge said, look, in view of her daytime sleepiness and the need to nap, I think that Lincoln's rationale is full of, blew them out of the water. The court noted that the reports and opinions of Lincoln's physicians didn't have any in-depth analysis of her narcolepsy, her symptoms, and her functionality. In fact, most of them actually failed to mention the narcolepsy. And the court said, look, you can't necessarily reject her diagnosis and her restrictions because she isn't getting significant treatment. The judge, said narcolepsy is not curable and it doesn't go into remission. And there are just certain levels of treatment that you're going to get, and that's what it is. In fact, the judge actually looked at medical articles to confirm this and the need for naps and the fact that, you know, once you're sort of getting a baseline of treatment, that is what it is. And if you aren't responsive, you probably aren't going to be responsive. The judge said to the carrier, "Too bad, so sad. Your rationale makes no sense in conjunction with his diagnosis," and awarded her benefits. That was a great result, and we really appreciate it when a judge takes the time to understand the nature of a disease like narcolepsy, its ongoing problems that it causes without warning and on a daily basis, and the fact that it isn't curable. So congratulations to Ms. Bombassi. If you have any questions about your rights to ERISA disability benefits as a result of narcolepsy, give me a call at 727-894-3188 for a complimentary consultation.